The state engineer stood perfectly still in the middle of the dried-up riverbed. His boots crunched on the cracked mud as he knelt down and picked up a piece of rusted metal pipe sticking out of the ground. Behind him, 3 officials from the Ohio Department of Natural Resources exchanged nervous glances. One of them finally spoke. "How old is this system?" The engineer checked his tablet, then looked back at the pipe. According to county records, 1968. He stood up slowly and turned toward the small crowd gathered near the fence line. Bank officials, a lawyer, a surveyor, and a construction crew that had been about to start demolition that very morning. And standing off to the side, alone, was a 68-year-old man named Raymond Cole. He wore faded jeans, a denim jacket with holes in the elbows, and a ball cap so old the logo had worn off. He didn't say a word. He just stood there, arms crossed, watching. The state engineer walked toward the bank's attorney, a sharp-dressed man named Philip Stratton. "Mr. Stratton, do you have any documentation showing that your client acquired the water rights associated with this property?" Stratton blinked. "Water rights?" "Yes. This land sits on a priority water diversion from the Hocking River, established in 1968. If your client took possession of this property without those rights, you've got a serious problem." Stratton's face went pale, and for the first time in 6 months, Raymond Cole allowed himself a small, tired smile because the bank had taken his land, but they'd forgotten to take the one thing that mattered most. Raymond Cole had never wanted much out of life. Just a quiet place to live, a little land, some peace. He'd bought 9 acres along the Hocking River back in 1994 with money he'd saved from 20 years of working as a freight dock supervisor. It wasn't a farm. It wasn't fancy. Just a small house, a gravel driveway, a shed, and a lot of trees. But it was his. His wife, Diane, had planted a garden every spring. They'd raised 2 kids there, celebrated birthdays, survived rough winters. When Diane passed in 2017, Raymond stayed. He couldn't imagine being anywhere else, but staying wasn't easy. The loan in 2019, Raymond needed a roof replacement. The old shingles were rotting, and water was leaking into the attic every time it rained. He didn't have the money, so he went to First Colonial Bank in Iron County and took out a small home improvement loan, $22,000 fixed interest, 5-year term. The loan officer, a friendly woman named Grace Portman, walked him through the paperwork and assured him it was straightforward. Raymond signed. For the first 3 years, he paid on time, every month, never missed. But in 2022, Raymond had a heart attack. He survived, but the medical bills buried him. He missed 2 payments, then 4, then 6. By early 2023, the bank sent him a default notice. Raymond called them immediately, explaining his situation. He asked for a payment plan. They offered him one, but the terms were brutal. The new monthly payment was almost double what he'd been paying before. He tried. He really did, but by October 2023, he was behind again, and that's when First Colonial Bank moved to foreclose. The auction on a cold morning in February 2024, Raymond stood outside the county courthouse and watched his property get auctioned off. He didn't go inside. He couldn't. He just stood by his truck in the parking lot, hands shaking, as strangers bid on the only home he had left. The winning bid came from a local real estate development company called Summit Crest Holdings. They paid $68,000. The same day, Raymond received an eviction notice. He had 30 days to vacate the property. Moving out Raymond spent the next 3 weeks packing up his life. He put Diane's garden tools in boxes. He took down pictures from the walls. He loaded his truck with whatever he could fit. The rest he had to leave behind. On his last day, he stood in the driveway and looked back at the house. The front door was still open. The windows were dark. He thought about all the years he'd spent there, all the memories. Then he got in his truck and drove away. He didn't look. Back the new plan, Raymond moved into a cramped efficiency apartment on the edge of Iron County. It was all he could afford: 1 room, a hot plate, a bathroom the size of a closet. He got a part-time job stocking shelves at a hardware store just to cover rent. Most nights, he sat alone and stared at the wall. He felt like a failure, like he'd let Diane down, like he'd lost everything. But then, One night in late March, he got a phone call. The voice on the other end was unfamiliar. "Mr. Cole? My name is Vanessa Ruiz. I'm a field agent with the Ohio Department of Natural Resources." Raymond sat up. Okay, what's this about? "We're conducting a routine audit of water rights and diversion permits in Iron County. Your name came up in our database as the holder of a 1968 priority water right associated with a property on County Road 41. Raymond's heart skipped. That was my property. I lost it. The bank foreclosed. There was a pause. "Mr. Cole, water rights don't automatically transfer with property sales. They're separate. If you still hold that right, and the new owner is using the water without authorization, that's a violation of state law." Raymond felt his breath catch. I didn't know I had a water right. Let me send you some information. Can we meet?" Yes, the meeting. 2 days later, Raymond sat in a small conference room at the DNR field office in Athens, Ohio. Vanessa Ruiz was in her early 40s, sharp, organized, and no nonsense. She laid out a stack of documents on the table. "Mr. Cole, in 1968, the previous owner of your property, a man named Ernest Calloway, applied for and received a priority water diversion permit from the state of Ohio." She slid a faded, official-looking document across the table. It had a state seal, signatures, dates. This permit gave him the legal right to divert water from the Hocking River for agricultural and domestic use. That right was tied to the land, but it was also recorded separately in the state water registry. Raymond stared at the paper. "I bought the land in 1994. Nobody ever told me about this." "That's not uncommon," Vanessa said. "A lot of these old permits get forgotten, but they don't expire. And when you bought the property, this right transferred to you. So I still own it." "Technically, yes, unless you signed it away, which you didn't." Raymond's hands were shaking now. "The bank. They took my land. They sold it." "They sold the land," Vanessa said carefully. "But unless the deed specifically included the water right, and unless you signed a separate transfer document, that right is still yours." She leaned forward. "And here's the problem. Summit Crest Holdings just submitted a development plan to the county. They're planning to build a private recreational facility on your old property, with a man-made pond, irrigation system, and water features. All sourced from the Hocking River." Raymond felt his chest tighten. "They can't do that without the water right, can they?" Vanessa shook her head. "No, they can't. The documents." Vanessa pulled up a digital map on her tablet. It showed Raymond's old property outlined in red. Overlaid on top of it was a blue line, representing the 1968 water diversion system. This system was built decades ago. It's still functional, and according to state law, you have priority access over any new claims. "So what do I do?" Vanessa handed him a business card. "You need a lawyer. A good one, because if Summit Crest tries to use that water without your permission, they're violating state water law, and that could shut down their entire project." Raymond looked at the card. It had a name on it: Marcus Hale, Environmental and Water Rights. Attorney Marcus Hale worked out of a small office in Columbus. He was in his mid-50s, with silver hair, glasses, and a reputation for taking on cases nobody else wanted. When Raymond called, Marcus listened to the whole story without interrupting. Then he said 4 words. "I'll take the case. Building." The case Marcus worked fast. He requested certified copies of the 1968 water permit from the state archives. He pulled the deed records from Raymond's 1994 purchase. He reviewed the foreclosure documents, and most importantly, he reviewed the sale agreement between First Colonial Bank and Summit Crest Holdings. What he found changed everything. Nowhere in the sale documents was the 1968 water right mentioned. That meant the bank had sold the land, but not the water, and Summit Crest had unknowingly bought a piece of property they couldn't fully develop. The Falingone, April 18, 2024. Marcus filed an emergency injunction in Iron County Court. The filing requested immediate cessation of all water-related construction on the former Cole property. Recognition of Raymond Cole's continuing water right under the 1968 permit compensation for unlawful use of water, if any diversion had already occurred, Within 48 hours, the court granted a temporary restraining order. All construction on the Summit Crest project stopped. The pushback Summit Crest was furious. Their CEO, a man named Gerald Fenwick, immediately hired a high-powered law firm out of Cleveland. They argued that the water right was invalid, that it had been abandoned, that it wasn't enforceable, but Marcus had done his homework. He showed that the diversion system was still intact, that Raymond had used the water system up until the day he was evicted, and that under Ohio water law, priority rights don't expire unless formally relinquished. The court scheduled a full hearing, May 6, 2024, Iron County Courthouse. Raymond sat beside Marcus at the plaintiff's table. Across the aisle sat Gerald Fenwick, Philip Stratton, and a team of 3 attorneys. Judge Claudia Brennan presided. She was known for being fair, but tough. This court will now hear arguments in the matter of Cole v. Summit Crest Holdings regarding contested water rights. Mr. Hale, you may begin. Opening argument. Marcus stood. Your Honor, this case is very simple. In 1968, the state of Ohio granted a priority water diversion permit to Ernest Calloway. That permit transferred to my client, Raymond Cole, when he purchased the property in 1994. It was never sold. It was never relinquished. It still exists. He placed a certified copy of the 1968 permit on the projector. The document filled the screen. Mr. Cole lost his home to foreclosure. That's tragic. But losing your home doesn't mean you lose your water rights, especially when those rights were never part of the foreclosure sale. Summit Crest bought land, but they didn't buy water, and without that water, their development can't proceed. The defense, Philip Stratton, stood next. Your Honor, this so-called water right is a 56-year-old piece of paper that hasn't been actively enforced in decades. My client had no knowledge of its existence. The sale was conducted in good faith. Furthermore, Mr. Cole abandoned the property. He left, he moved on. To now claim he still has rights over something he no longer owns is absurd. Judge Brennan looked at Marcus. Mr. Hale? Marcus didn't hesitate. Your Honor, water rights in Ohio are governed by prior appropriation and beneficial use doctrines. My client used that water system continuously until he was evicted. He didn't abandon it, he was removed from it. And as for good faith, ignorance of the law is not a defense. Summit Crest had a duty to perform due diligence before purchasing the property. They failed. The state weighs, and then something unexpected happened. Vanessa Ruiz entered the courtroom. She approached the bench and asked to speak as a representative of the Ohio DNR. Judge Brennan allowed it. Your Honor, the state has a vested interest in protecting established water rights. The 1968 permit held by Mr. Cole is legitimate, active, and enforceable. If this court allows a private entity to bypass that permit, it sets a dangerous precedent for water law across the state. She paused. We support Mr. Cole's claim. The courtroom stirred. Stratton's face went tight. Engineer's testimony. Marcus called the state water engineer to the stand. He testified that the 1968 diversion system was still intact, that it had been professionally installed, that it was still functional, and that any new water used on that property would legally require Raymond Cole's authorization. Without his consent, Summit Crest cannot legally access the Hocking River from that site. The final exchange of Stratton stood for cross-examination. Isn't it true that Mr. Cole could simply sell this water right to my client and resolve this entire matter? The engineer nodded. Yes, if he chose to. Stratton turned to Raymond. So why don't you, Mr. Cole? Why drag this out? Raymond looked at Marcus. Marcus nodded. Raymond stood slowly. Because you didn't ask. The room went silent. You took my home. You put me out on the street. You didn't care what it meant to me. His voice cracked. And now you want me to just hand over the one thing I have left, so you can make money off the land I loved? He shook his head. No. Judge Brennan banged her gavel softly. Mr. Cole, please sit. Raymond sat, but the message had been delivered. The ruling Judge Brennan took less than 10 minutes to decide. I find that the 1968 water right held by Raymond Cole is valid, enforceable, and was not transferred in the foreclosure sale. Summit Crest Holdings does not have legal access to water from the Hocking River without Mr. Cole's express authorization. The injunction is made permanent. All water-based construction is halted until this matter is resolved between the parties. She looked at Stratton. I suggest your client negotiate. 3 days later, Raymond sat in Marcus's office. Across from him was Gerald Fenwick and his legal team. Fenwick didn't look happy, but he was there. Mr. Cole, Fenwick began, we'd like to purchase the water right from you. Raymond didn't respond. We're prepared to offer. A $20,000, Raymond glanced at Marcus. Marcus leaned forward. My client is also interested in reacquiring the land. Fenwick blinked. The land isn't for sale. Then neither is the water, Marcus said calmly. Silence. Fenwick exhaled slowly. What do you want? Raymond spoke quietly. I want my 9 acres back. You can keep the rest of your development. But I want my home. Fenwick stared at him. That's not reasonable. Then we'll see you in court, Marcus said, standing. Fenwick held up a hand. Wait. The final agreement. 2 weeks later, the deal was signed. Summit Crest returned the original 9-acre parcel to Raymond Cole. In exchange, Raymond granted them a permanent easement to access water from the Hocking River, but only for specific, agreed-upon uses. He also received $85,000 in compensation. The bank Maisut First Colonial quietly settled a separate claim to avoid further legal exposure. Going home on a warm morning in June, Raymond Cole pulled his truck into the gravel driveway of his old home. The house looked the same. The trees, the shed, the garden. He walked slowly to the front door, unlocked it, and stepped inside. It smelled like dust and old wood, but it smelled like home. He walked to the back window and looked out at the river. The water was flowing, just like it had been in 1968, just like it always would, Raymond. Cole didn't set out to fight a corporation. He didn't want to be in court. He just wanted to keep the life he'd built. But sometimes the things we forget, old papers, old permits, old rights, turn out to be the things that save us. The bank took his land, but they couldn't take the water, and in the end, that made all the difference, because the law doesn't care how much money you have. It doesn't care how big your company is. It only cares about one thing: who has the right. And on that day, in that courtroom in Iron County, Ohio, Raymond Cole had the right Iron County, where the truth runs deep.